Happy Palm Sunday for all Southern Cameroonians. The one a day where the Roman Catholic Church began decree following the Roman calendar, say they go to celebrate the day where Jesus Christ be enter for inside Jerusalem. So for people where they follow the Jewish calendar, where Moses be bring them, like we for Judaism, would is also see recognize one as a Christian day for celebrate a day where it be different for the Jewish calendar. But happy Palm Sunday, na a wonderful day. I remember my day them for Bamenda, who been at the Baptist people them where we be the dance go for upstation, dance through town, and a wonderful experience for learn about the history for God where he come turn into human being. So today, ladies and gentlemen, for the public interest, because this case for Ayaba Cho is a public interest case, the PRAP organization will put out a word-to-word translation for the court document so that make all our people them fit understand which way it happen. This document it will be obtained directly from the court clerk out of a request by PRAP for public interest, for public information. We get three sources of information. One, this document will come up for court, then send them for us through email. We'll get phone conversation with the court clerk for get general, publicly accessible information. We also get a person who attend the court hearing in person, an Ambazonian will attend in person, a legal practitioner for Norway. We also would then contact the prosecutor's office, their human resource management, that means a person where they talk for press people, then forget also information. So those are the informations we have. They are credible. They are information you can take it to the bank. So now I will go ahead for read the translation. This one now not be a Google translation. Now an app where they use them for lawyer and where they translate things properly for English from legal terms. I go read them word to word, and I go also translate which way the court document it talk for pidgin. So this is the court document. It is signed. It is Oslo District Court, Oslo Tingrit. The name for the court, now the name for the court and Tingrit. Case record. Date 10 of March 2025, 8:30 a.m. A hearing was held at the Oslo District Court. Case number 25/03865-1-ENE-TOSL-03. Judge. Deputy Judge with General Authorization, Sondres Andreas Berg Paulson. Now they named that for the judge where he handled the case. Case concerns request for continued detention. That means the case now the Norway government will bring them again for court. Down it talks a prosecutor versus Cho Lucas Yaba, born on 11/8/1972. No restrictions, no public disclosure. No restrictions on public disclosure. That means the judge talks say all things will happen for the court. They fit talk for outside. They fit explain them for the public. You know, talk to me they hide anything for the public. Ruling. So this one now the ruling, the decision of the court. Separate this from every commentary on the debate where we go on for court between the two lawyers. So I read now the document now, direct translation. Rulings. That means the decision of the court. Now you are read them now so. By a decision from Oslo District Court dated September 25, 2024, Cho Lucas Yaba was detained under Section 171, first paragraph, second remand order dated October 27, 2024, charged with violating Penal Code 108 and Penal Code 106, first paragraph, letter A, E, F, and G, for complicity in crimes against humanity. His detention has since been extended several times, most recently by court order in February 10, 2025. The prosecution has now requested the court approval for continued detention for up to 8 weeks. For my country people them, it don't call the law them way Ayaba Cho they want talk say them broken for Norway. Then talk say them broke 2 penal code them way all them constitute na complicity for crimes against humanity. That means say being an accomplice for some crime them way they don't already commit them for ground zero. For crimes, man not talk the place because they not talk the place for this particular court document for ground zero. Now make a continue for read the document. The court finds there is probable cause to suspect the defendant of a criminal offense punishable by more than 6 months imprisonment, specifically a crime against humanity under Penal Code 108 and 102. That means say then talk say the court idan see say reason day for them for believe say the accused person Ayaba Cho idan commit crime where they feel put it for prison for more than 6 months imprisonment, and then he give the penal code them for the crime. As described in the indictment, the court referred to the evaluation in previous decision, especially the ruling from Bogotá Court of Appeal in December 6, 2004. They cite the document 13, document 3, document 19. It means that the court where it decide it talks say for December, the one that will not be known. So for December, for 6 December, the Ayaba Cho court they be appeal, they will go for court of appeal. For go appeal say they no get no case against Ayaba Cho, but the court he agrees say the evidence and shows say they get case against he. Now anyway the court it is cite the document, the court judgment for court of appeal against Ayaba Cho. That court of appeal it just simply talk say Ayaba Cho they become for court talk say they don't get evidence them where support the charge with the game for ye. Then the court he find them say they get evidence them. Now why that way the court decide that one like reason, part of the reason for the consideration for this case. May we continue for read. No new information weakens the suspicion against the accused. So this statement it means say the judge talk say they never give any new information where it show say they know where government you know get right for belief say Ayaba Cho don't commit the crime them. I continue for read. The court has noted the defense objections regarding the formulation of the indictment, but that these are not decisive for assessing the probable cause. So then talk say the court didn't hear Ayaba Cho their defense. The defense lawyer for Ayaba Cho, it talks the way they make the indictment, that means the way they link it for the crime them, it not be decisive. It means action, participation for those crime them, it not be very strong. The judge talks he didn't hear their argument, but he don't talk, he believes say the court, the Norway prosecutor, he get reason for belief say Ayaba Cho he don't commit those crime them. I continue to read the document. Previous detentions were justified by the risk of evidence tampering. The prosecution now bases the new request for detention on risk flight. So the judge he talk for this record document where they are released and say say the time where they began the extend Ayaba Cho in detention, the reason where the government will know where with the gam, now say the fear say Ayaba Cho go tamper with evidence them. But now the Norway government it talks say Ayaba Cho, the reason where they gam for the particular time now say Ayaba Cho if he run, it be risk for flight. Make we continue for read the document. According to section 184, second paragraph, first sentence, section 171, first paragraph, item 1 of the Criminal Code Act, a suspect may be detained if there is a reason to fear that they will evade prosecution or sentencing. So it is no code law for Norway their court way talk say they feel continue for detain some person if them believe say the man if he run away may they not sentence he, or the man if he run down way then sentence he. So they feel continue for hold you. I continue for it. It is not required to prove a high likelihood of escape, but there must be concrete objective indicators in each case to determine a flight risk. So the judge talks say you don't need for prove and say some person if he likely run or not. But when you feel prove and say things in the way it shows say the person if he run, it be enough. Then I continue for it. It says Supreme Court Precedent 211, page 329, the escape does not need to be permanent. Even risk of short-term flight qualifies in page 972. Then talk say if person they get risk if he run, you no need for sure say the risk lead permanent, but the court need for consider and whether the person if he truly run. Then I continue for it. The court finds this condition to be met. The court note that the accused have relatively weak ties in Norway, while he has lived in Norway for many years and has a child born in Norway. Neither his child nor his spouse are Norwegian citizen. That means the judge talk say, Ayaba Cho that meet up the condition where they fit continue for keepy. Then I read now which way they already established him after they don't argue. The lawyer did not argue based on information they give him. So the one a commentary now, no be two way he did for the. But wait to way talk for the nazareti. Say the court say Ayaba Cho overget strong root them for Norway. Even though Ayaba Cho done born picking for Norway, and a woman too, it stay for Norway, a woman and that picking no be Norwegian citizen them. I continue for it. The accused is German citizen and currently unemployed. Wanna hear? The judge talks according to my conclusion, because this judgment na record for conclusion. So the judge talks Ayaba Cho na German citizen and he be jobless. I continue for it. He reportedly runs a small business, but has been on sick leave since December 2023 and was declared unfit in September 2024. He has no family ties to Norway. So he talks that Ayaba Cho begins on small business where they run them, but for 2023, he decides he will get sick leave. Then for 2024, then declare say he be unfit for work. According to information we get for the court cases, for the argument we did for court, do not be for the ruling, for the argument, Ayaba Cho they take government money for welfare. So he don't declare say he not be fit for work. That means say he gets on sickness where he not fit do work. So now the thing that way the court judgment he talk him. We'll read the next passage. The court further notes that data retrieved from his computer indicates that he and his families are planning to move to England. He holds residency in England, and his wife has applied for residency based on his permit. The accused is charged with a very serious crime and has a strong incentive to evade prosecution. So it talk for you say Ayaba Cho the court dan see document where the government then show say then take for Ayaba Cho a computer. Where it talks say a woman that apply for residency for UK also, where Ayaba Cho to get resident permit for UK. So it shows say Ayaba Cho it plan for go for UK. And the kind case the way they charge Ayaba Cho na strong case the way if you make him run, make a continue for it. Combined with these weak ties to Norway, a concrete evidence suggesting plan to move to England, the court finds flight risk condition clearly met. That means the court then look the serious charge where Ayaba Cho face him, and then he see the plan where Ayaba Cho be the plan to go for London. He see say Ayaba Cho if he run this case. So now why that way they will continue for Holy. The court also notes that the accused considers his connection to Norway strong and stated that he has no intention to flee, especially as it reflects negatively on the liberation movement he leads. It was also noted that the accused owns property in Norway worth 6.4 million, that is around $600,000. However, he is deemed decisive. That means the court then talk say Ayaba Cho talk say he no fit run it because he go make people to go the lavy for this struggle say don't run. So he no fit run. Me the court believe he say he no run. And then he show so say get house where he buy him 600,000. But the court he look and say Ayaba Cho he no be honest. I continue for it. The prosecution has requested detention for 8 weeks under section 185 of the Criminal Procedure Act. The detention period should be as short as possible and not exceeding 4 weeks unless special circumstances applied. So the judge talk for the part say the prosecutor either asks the court me them keep Ayaba Cho for very long time. But this law it talks say they fit keep person only for 4 weeks unless na some special circumstances and the way it require me to make me pass 4 weeks. I continue for it. If justified, a longer period can be granted, in this case, the court finds that special circumstances justify extending the detention period beyond 4 weeks based on risk of flight. So the judge talk say the Ayaba Cho case they so it get special circumstances the way they fit justify for extend them. They want a very bad indication for a prospect for success for this case. I continue for it. The court finds that continued detention for 8 weeks is not an disproportionate invention. According to the law, the court has considered the seriousness of the offenses, the expected sentence, and the strength of suspicion. The risk of absconsion is evident. So the court then look how serious they think the way that they charge Ayaba Cho for court it be, and then he also checks seriously the expectation of sentence. That means if they sentence you for this case, if you sentence up to 30 years imprisonment based on the charges itself, so the RAN decides to go wholly for prison because of this. I'll continue to read the last 3 paragraphs. The prosecution has stated they expect the case to proceed to trial within 2 years of his arrest. The court considered this very long time. However, due to severity of the case and the international connections, continued detention during this time frame is considered appropriate. Let me say the court it talks away. Say the government for Norway it talks say then believe say before they go take Ayaba Cho go try for court, it will take like 2 years based on the international nature of the court of the case. And the judge talks say Isiam say even though that 2 years is over long before the case could really start, if he say he also still be reasonable for keep Ayaba Cho for prison when the time for detention is day, if he say be appropriate because of the thing the way that the charges say and do. I continue for it. The complexity of this case justify a longer period of detention under Article 5, number 3 of the European Convention of Human Rights. That means that the judge talks say even under European Constitution for Human Rights, it be justified for who Ayaba Cho for up to 2 years waiting trial because of the grievances, the gravity for which they charge you for. I continue for it. Alternative measures, section 188, such as confiscation of passport or reporting obligation, are not sufficient to mitigate flight risk. So he talks say the way they feel release person, you go shoot down for house, then talk me you can the report for police, and then seize your passport. All those one they no fee stop Ayaba Cho for run if they release you from detention. The court therefore grants the prosecution request and set detention period to 8 weeks. So this podcast not just a direct translation for this Ayaba Cho case document we'll get them for court. Other commentaries are all based on the arguments made in court, submission by Ayaba Cho's own team, and submission by the prosecution. But the one at the final document where it come out. The information about Ayaba Cho's joblessness, if he jobless, the court does state them so. For the argument, the prosecution proves say the submission where Ayaba Cho be proven, it shows say he no get no history for income, even though he be get small business. Because what they do for abroad and say if you get business, then they talk say your business they work on losses or something like that. But he no get no business for 2023. He declares say he be unfit for work. That means in a man way he no fit work. The reason them I think say he be very private and personal. Even we need for get dignity for not talk all thing we don't hear them, all thing we know them, we not put them for outside. But ladies and gentlemen, these are the court documents about Ayaba Cho. You deserve to know, unfiltered, and make your opinion on your own. Our job is to empower you with the knowledge you need in an era of confusion and propaganda. You need to know exactly what the court document says about him. God bless you. Happy Palm Sunday for everybody. And the victim for those who didn't die, for me in particularly, Pa Chietan with and Kili for Bamenda where JC come for a house. Ayaba Cho then Seni. They can kill that pa when that pa be convinced tanker, convinced Alabukam, Cobra, cross and die, me then join ADF, me then swear say the one for join ADF. Now me I use that pa so for convince them. Then can go kill that pa in front of a woman. That pa blood it go there for their head. And for people the way they feel say they fight for Ambazonia, the blood for Kemende. They no fit stand for fight for justice for Kemende and all the victims for Ayaba Cho. They don't lost their soul. We know how they be catch Kemende and Motona for Ayaba Cho. He come. The general way they be take cash lawyer, where the lawyer go for they go eyewitness, those things them. All of those things are not joke. Those are serious things. We cannot ignore them. This does not mean that Cameroon is free. We don't see Ngala Gerati own killing for Bui. We don't see the oil killing for Garbu. With militia, when Naibi can stand announce and say Naibi bring them for Nigeria. It is still work free. And many other people where they don't commit war crimes. Any man where don't commit war crimes need to go for the crime. No human life is supposed to be taken lightly. During my time with the Egg of Season, people they talk say no, I don't work with Ayaba Cho. Time when I work with Ayaba Cho, when I feel look all of my declaration, I don't always talk say me no soldier no get right for kill any man. Even when accused of being black leg, that soldier must, the condition I be dictated and I say, you must present the evidence to 2 other generals and must confront the accused person with the evidence against him. Because sometimes people can manufacture lies, sometimes you can even see evidence, but in close examination, you will see that those evidence was not real. You cannot kill people just to terrorize people and keep people in line. That is called terrorism. You can't do that. Not in my name. I've said it when I was with Seseko Ayoktabi. I said it when I was with the Tigers of Ambazonia. I said it as an independent activist. I will continue to say it again. I rejected such attacks against our people by Eric Tato and they called me names. It didn't change who I am. This is who I am. We fight for our people. We must do so honorably because that is what it takes to fight for those people. God bless you all. Have a good day.